But yeah, good afternoon, everybody. Thanks for joining us for today's webinar. My name's Summer. I'm the Projects and Events Manager for MPAQ. Today I'm just moderating. Today we're joined by Amy Edmonds, the Senior Workplace Relations Advisor from Citation HR. Amy, thank you for joining us.
Thanks for having me.
Today we're going to be talking about the Fair Work Legislation Amendment Closing Loopholes Bill and the numerous changes that will take effect primarily from the 26th of August 2024. If you do have any questions, feel free to just use the raise your hand and ask out loud, or use the chat function if that's more comfortable for you. We'll either answer them throughout, or we'll just come back to any questions at the end as well. But Amy, I might let you take over.
Sure. Let me know when you see presentation.
Yeah.
Can everyone see my slide? Awesome. So thanks again, everyone, for attending the Closing Loopholes Bill presentation. As Summer mentioned, my name is Amy Edmonds, and I'm a Senior Workplace Relations Consultant at Citation HR. So we provide outsourced HR solutions, particularly when it comes to employment relations matters. So I joined Citation over 2 months ago, and I've probably been in contact with a few of you via the telephone advice line. But if I haven't met you, I'm sure I will meet you over the next coming weeks and months. Before we get started, I'll quickly explain some of my background. I've had over 8 years experience working in HR. And although most of my experience comes from working in internal HR teams, I have primarily experience on ER matters. So that's for companies of various sizes and industries. And particularly, I've been working on matters that involve the very complex and dynamic relationship between employees and their employers. So specifically, I'm talking about, complex terminations, workplace investigations, and other disciplinary and performance management processes. So whilst today we're probably not going to focus on these things, we're going to talk about some very important legislative changes that are all relevant to you and your employees. So I'm going to start off today with casual employment, what it means now, what it will mean later this year, and your responsibilities as employers to convert or not convert casual employment. Also talk about the new legislation around the right to disconnect and how this may impact you, and the importance of paying your workers correctly and the consequences of not doing so. Currently, our definition of casual employment is this. They're offered a job, and the job offer does not include a firm advance commitment that the work will continue indefinitely and with an agreed pattern of work, and that they accept the offer knowing that there is no firm advance commitment and become a casual employee. But now, effective the 26th of August this year, there's going to be a new definition of casual employment. As of August, an employee is only a casual employee if the employment relationship between a casual employee and employer is categorized by an absence of firm advance commitment to continuing and indefinite work. And I'll discuss more about this firm advance commitment in the next slide. And secondly, the employee would be entitled to a casual loading or a specific rate of pay for casual employees under the terms of a Fair Work instrument, such as a modern award. And if the casual employee is entitled to a casual entitlement, like a casual loading or rate of pay under their contract of employment. One thing to note, and I put that in italics at the bottom of the slide, is that an employee who commences employment as a casual will still remain a casual only until the occurrence of a specified event. And I'll explain what some of those events are shortly, but let's talk about firm advance commitment. As I mentioned before, a casual employee relationship must be characterized by an absence of a firm advance commitment. To determine whether there is that firm advance commitment to continuing an indefinite work, we need to look beyond the job contract and what it says and the job description, and assess several key aspects about or around this relationship. So firstly, we want to look at the real substance. We need to understand what that job truly involves. What does this casual role really involve? This means looking at the day-to-day reality of the role and not just looking at its job description. An example of this is an employee whose job description perhaps states that as a permanent plumber, they'll be handling planned maintenance tasks and installations in commercial or residential properties. In reality, though, the employee may be checking their phone daily for new job requests or taking urgent calls, and might be called in to the evening or even weekends to work. These responsibilities, which are not mentioned in the job description, show what their job truly involves on that day-to-day basis, and it probably is, a casual employment relationship. The practical reality is another factor that we need to look at. So we need to consider how the job operates in practice. This includes interactions between the employer and employee and how the job functions in the real world. And an example of this is an employee who, although his contract indicates a permanent role, the practical reality is that his schedule changes and is unpredictable based on seasonal demand. So during peak seasons, he's required to perhaps work extra hours or handle staff shortages, which therefore reflect those real operational demands and how the job functions in practice. Finally, the third key factor here is the true nature of the role. So assess the actual nature of that employment relationship. Is it structured to be long-term? Or is it something that's more flexible and temporary? An example of this may be an employee whose contract states a permanent role. However, the nature of their role is project-based with no guarantee of any ongoing projects. This means that perhaps their employment relationship is more flexible and temporary, lacking that long-term commitment that's associated with permanent roles. Outside of those three main factors, the real substance, the practical reality, and the true nature of the role that I've just described to you, there are some other key factors here that we need to consider. The work offering. Can the employer choose to offer and not offer work? And is this actually happening? Work acceptance. Does the employee have the choice to accept or reject work? Future work. Is it likely that there will be ongoing work available in the business, considering what the business actually does? And other workers, are there other employees, either full-time or part-time employees, that actually do this similar or the same work? And finally, a regular pattern. Does the employee have a consistent work schedule? By examining all of these elements, we can better understand if a job has a solid or firm advance commitment to being long-term and ongoing, and thus should help us determine whether a casual employment is a real, true casual employment relationship. As I mentioned before, we have an employee remains as a casual employee until the occurrence of a specified event. What does that mean? This means that essentially a casual who commences employment as a casual will remain a casual unless either their employment status has changed from to full-time or part-time employment. The employee's employment status is changed by order of the Fair Work Commission, 3, the employee's employment status is changed to full-time or part-time employment under the terms of a Fair Work instrument, such as a modern award. Or finally, the employee accepts an alternate offer of employment other than as a casual employee. So there are 4 different ways that can mean the change of that employment relationship. There's actually now a very clear framework to demonstrate a casual conversion change. And the new employee choice pathway differs from our current position in terms of casual employment, and that's in 2 different ways. So currently, the first is that larger employers will no longer be required to conduct a review of long-term casual engagements and determine whether to offer a permanent position. So if you own a large company, you're no longer required to assess the work schedule and work arrangement of a casual over the last 6 to 12 months. Now, action will only need to be taken by an employee choice notification. So from August, the onus is on the casual employee to request casual employment conversion. The second point that we need to think about here is that an employee can only activate this new process by claiming that their job has already become an ongoing one. So they need to already be working in a potential, full-time or part-time arrangement to be able to claim casual conversion. Merely having worked on a regular basis for 6 or 12 months will no longer be enough, as it would have under these current provisions. So if we look at this framework here, we can see what's really required for casual conversion. An employee firstly gives written notification to seek conversion, only if they no longer believe they are a casual employee, according to the new definition of casual employment, as I mentioned earlier. Secondly, as an employer, you will need to consult with that employee and discuss the implications of that conversion. That might be that they'll no longer receive certain entitlements, such as casual loading, and may potentially no longer receive, that higher hourly rate of pay. As a third step, an employer must respond within 21 days of that employee conversion request. An employer can only refuse, however, on the basis of 3 certain points, and that's if the employee still meets the definition of a casual employee. Secondly, if there are fair and reasonable business grounds for not accepting this casual conversion request. Or 3, conversion will result in the employer not actually complying with law and legislation. If an employee doesn't agree with you as the employer's response, the employee may refer the dispute to the Fair Work Commission, who can resolve that dispute and may make an order if it considers it's fair and reasonable to do so. There are some other important changes that pertain to casual employment that I want to raise with you. The first is the casual employment information statement. So I'm sure you all know what that is. It's essentially a document issued by Fair Work that lists all the minimum terms, lists all the terms and conditions of casual employment. It's usually on a 1-page document, and every casual employee receives that prior to or at the start of their commencement as a casual. New changes as part of the new legislation means that if you were an owner of a non-small business, you will need to issue this document 6 months after a casual started employment, and then 12 months after employment, and then every subsequent period of 12 months following that. If you are a small business, casual employees are only required this document at the start or prior to commencement of employment, and then 12 months following that. There are two new anti-avoidance offences regarding casual employment. And what does that mean? Well, essentially it means that employers cannot dismiss or threaten to dismiss an employee in order to engage them as a casual employee, or to do the same or substantially similar work as a casual, or make knowingly false statements in order to influence an employee to enter into a casual employment contract or to perform the same or similar kind of work. And actually, contravening either of these provisions can attract some really serious, significant penalties. So it's important that we keep these anti-avoidance provisions in mind. There are some traditional provisions as well that we probably just need to consider. These new amendments would deem that all existing casual employees as of the 1st of July are casual employees within the meaning of the new definition. So anyone who's a casual employee right now is a casual employee under the new definition that I've explained earlier in this presentation. Now, it's good to know that continuing casual employees are likely to be inconsistent with this new definition because they've worked, very regular hours for an extended period. A casual employee that is employed prior to the 1st of July would also continue to be a casual unless they convert. It's important to note that any service as accrued by a casual prior to the 1st of July is actually not recognised for the purposes of participating in the employee choice pathway. They must be able to show that they are not a casual due to ongoing and indefinite work, and previous work patterns aren't considered. Despite safeguards to this employee choice framework, casual employees may still be able to commence a dispute about whether or not they were a casual employee when they commenced employment. An order may be made by the Fair Work Commission to declare that casual employee as a part-time or full-time employee. And this is only a problem in terms of back pay considerations. So you may, as an employee, be required to back pay the entitlements of a permanent employee that the employee didn't receive when they were a casual. Important to note that if you are stuck in this position, that an employer is likely to be able to offset any amount of back pay with a casual loading pay. So if you are paying your casual a casual loading and they potentially were, never a casual employee and it should have been categorized as a permanent or full-time employee, then you can use that casual loading amount to offset any back pay. You will have to also recognize that there are leave entitlements that employee may be required to have as well. I guess let's talk about something maybe a little bit more positive, the right to disconnect. So in August this year, Australia will be introducing new legislation that addresses the right to disconnect. It's aimed at managing that really blurry boundary between work and personal time in this new digital age. It's designed to prevent work-related communications from encroaching on an employee's personal time. This legislation ensures that employees have a clear boundary between work and their private lives, particularly in the context of remote work and digital communication. It means that employees can now refuse to monitor, read, and respond to contact from an employer or a third party, such as a client. This right also covers attempted contact outside of an employee's working hours. Employees will have the right to refuse contact outside their working hours unless that refusal is unreasonable. So when is it unreasonable? Contact is only unreasonable only if the contact is legally required. There are also some other factors that must be evaluated to determine whether that refusal is unreasonable. Firstly, we want to consider the reason for the contact. Why is the contact being made? Is it essential to the work, or is it just routine? How is the contact made? Does it cause significant disruption to that employee's personal time? Is the employee compensated for being available outside their usual hours, whether it's financially or through other benefits? Other factors that we need to consider include, does the contact require the employee to work outside their ordinary hours? And what is the employee's role and level of responsibility? Are they working in a position where after hours contact is more reasonable? We also need to consider the employee's personal situation, including any family or caregiving responsibilities that might actually impact the ability to engage outside of work hours. By carefully considering these, we need to ensure that the right to disconnect is respected, whilst balancing your needs as an employer and your employee's needs. So let's take the following example. Mark is a single dad and an experienced plumber at a small company. His ordinary hours, are from 8 a.m. to 4 p.m. His manager, however, has been calling him and texting him outside of work hours for urgent plumbing issues, and is expecting immediate responses. So, do you think the contact can be refused by Mark? Well, as an experienced plumber at a small company, he might be the only plumber who can assist this particular client. However, we also need to consider that as a single dad, he may have caring responsibilities where he can't leave his home outside of work hours so he can look after his children. So this is just a very typical example, but we need to consider all these different factors to be able to determine whether contact can be refused. The government has directed the Fair Work Commission to undertake a process that adapts this general right to disconnect into each of our modern awards. A model term will be inserted into all awards, including the plumbing and fire sprinkler award, this week, I believe, and will be relevant for all award covered employees. For those employees, there may be exceptions to the right to disconnect where the employer can contact an employee outside of work hours if they are being paid a standby allowance, for example, if the employer is contacting the employee just to notify them of their requirement to attend work or perform work, and if the contact is in accordance with a usual arrangement, for example, a work emergency or an emergency roster change. Now that the right to disconnect is part of our legislation, it is a workplace right by law. The right to disconnect is also now a protection under the Fair Work Act. This means an employee can actually make a claim if they argue that adverse action was taken against them for refusing to respond to their employer outside of work hours. So, as an employer, I really want you to be made aware of this and ensure that your staff aren't being, um, are not engaged in any performance management or disciplinary processes. And that includes termination just for exercising their right to refuse contact. We actually anticipate that this is going to be the most significant impact of the right to disconnect. It's going to be that, adverse action was taken. As long as there is a broad framework in place that complies with this new legislation with the right to disconnect, such as a right to disconnect policy and procedure, and employees are not punished for exercising this right reasonably, there shouldn't really be a cause for concern. Any disputes about the right to disconnect should be discussed and resolved at a workplace level. Employees should be discussing any issues with their employer before it needs to be escalated. We recommend that a dispute procedure be included in a right to disconnect policy so that employees can really understand how they can raise concerns so that the company can address them reasonably. Beyond these attempts, the Fair Work Commission is actually empowered to make orders to the employee either to stop refusing contact or the employer to stop the contact. Finally, I want to talk about some changes to wage underpayments. A new federal criminal offence of wage theft is now introduced. And it's not going to be effective this year. It's actually going to be effective early next year. So what does that mean for you? Well, essentially it means that employers who intentionally engage in conduct that results in the underpayment of any entitlements under the Fair Work Act or under the Modern Award could face significant criminal penalties under these proposed offences. For companies who engage in intentional wage theft, the proposed offence will carry a maximum fine of either 7.825 million if the court can't determine the exact underpayment, or 3 times the amount of a particular underpayment. For individuals who engage in intentional wage theft, a proposed offence will carry a maximum of 10 years imprisonment and a maximum fine of greater of the either 1.565 million if a court can't determine underpayment, or 3 times the amount of the underpayment that was determined. When an employer is found guilty of committing 2 or more offences, for the purposes of sentencing, the employer would be taken to be guilty of 1 single offence. So it's only intentional wage theft that applies, right? Well, yeah, pretty much. Under the proposed offence, the prosecution will need to prove beyond reasonable doubt that an employer intentionally failed to pay their employees their minimum statutory entitlements. Underpayments that are accidental, inadvertent, or based on a genuine mistake would not be caught by these provisions, so you can rest easy. An example of this may be a failure to make a payment due to a banking error. And these kinds of errors happen all the time. So it's really important for you to be able to find the distinction between intentional and a non-intentional underpayment. An intentional underpayment may be any unlawful set-off imposed by an employer on such an employee, such as a payback or a deduction of money that an employee is not permitted to. For example, an employee is required to pay back $200 a month for the use of a company vehicle, even though the vehicle was not specified as part of her employment benefits and not even in her contract. This deduction is unlawful, and if the employee didn't agree, it is intentional wage theft. Another example of intentional wage theft could be an employer requiring an employee to spend wages on a benefit that is not potentially an employee benefit. such as the payment for a laptop that is owned by their employer. So if I can give you a more specific example of this, is if an employee is required to use a portion of their own salary to purchase a company laptop that this employee requires for work purposes. The cost of the laptop is deducted from their salary over several months, even though it is owned by the company. This is considered wage theft because the deduction is not permissible under the Fair Work Act, and it's not actually a benefit that enhances an employee's own remuneration. So what happens if you have or you think that you've engaged in wage theft? To foster a culture of transparency and really encourage employers to come forward, this bill introduces a safe harbour framework. This framework is designed to offer a pathway for employers to address and really rectify any wage theft issues without facing significant penalties and criminal prosecution. Under this provision, if you discover that your business may have committed wage theft, then you can self-disclose this alleged contravention to the Fair Work Ombudsman. This allows you to enter into a cooperation agreement with the Fair Work Ombudsman. The cooperation agreement provides a form of protection, a safe harbour from potential criminal prosecution. However, it's important to note that any decision is entirely at the discretion of the Fair Work Ombudsman. And whether and again, when dealing with this cooperation agreement, the Fair Work Ombudsman will consider several factors that revolve around this wage theft, and that's firstly if it was whether there was voluntary disclosure. So has the employer made a voluntary, frank, and complete disclosure of the wage theft conduct? And also your past compliance. So what is your history with compliance under the Act? Have you had issues with wage underpayments and wage theft previously? But by voluntarily coming forward and really disclosing any wage theft issues, employers have the opportunity to avoid these really severe penalties and work towards compliance in a constructive manner. So that was a lot of information overload, I think, but hopefully that gives you a really good summary of some of the changes that are coming shortly and at the beginning of the year. Thank you so much for all attending. If you do have any questions, though, I think now would be the right time to raise them. Emma, is that right? Not sure how much time we have.
No, you did very well. Still got a little while. Thank you, Amy. Thank you so much for that. Does anyone have any questions that they want to? There hasn't been any put in the chat just yet. If anyone's brave enough to, we had quite a few join while you were talking, so some that weren't here at the beginning.
Okay.
Got one coming through by the looks of it. Emma, did you have one?
Yeah, I just had a query in relation to this. So you spoke about the casual employees and the existing ones from 1 July. What about the ones that are prior to 1 July that were kind of casuals, work fairly consistent hours? Will they be able to remain casual, and will that only be a specified event when they can elect to convert their employment to part-time or full-time?
Yeah, that's exactly. So you're asking whether employees employed as casuals prior to July 1st will still be required to be converted, even when their experience shows regular systematic work arrangements. Well, look, I think it's partly business discretion with this new legislation that's come out. The new casual definition means that we need to look at whether there's going to be ongoing and continuing work. So I mentioned that even though employment arrangements a large number of current casual employment arrangements are unlikely to be consistent with this new definition, we still need to consider whether there's ongoing indefinite work. And I think that is the key takeaway here. But any employees on the 1st of July will not be able to use their previous experience to be able to request conversion as part of that employee framework.
Mm-hmm. And so I guess the biggest risk is if you do engage somebody as a casual kind of from now and they are having that regular and systematic hours, the risk is they can make claims for back payments of like public holidays, annual leave, sick days.
Exactly.
Yeah.
I think if you've engaged with an employee and they commence as a casual and potentially never was meant to be a casual employee, then I think that's something, a different matter. So if you do think that is the case, please reach out to us and we can further discuss that matter with you. But it might be a matter of, converting now and potentially a lot of back pay.
Thank you.
Cool. Anyone else have any questions they want to ask about the bill or about anything that we've covered today? That baby woke up, Lauren. You lied.
Super cute.
Okay.
I guess I do have another question. I'm hogging the question.
Go for it. Yeah.
So you touched on about the right to disconnect. So for small businesses, is it 26th August this year, or I thought I saw it was something next year for less than 15?
Yeah, that's right. That's right.
Yeah.
For small businesses, it is a different date. But I think this is something that we really should bring to mind for small businesses as well. I know a lot of businesses keep this in mind or really ensure the employees have that work-life balance anyway. But look, August 2024 is for large businesses.
Yeah.
And I can't remember the exact date. I think it's in 6 months' time, 12 months' time.
So if a plumber is required to be on call, and they take the on-call phone for a week or a weekend, they essentially won't have a right to disconnect because it's reasonable business grounds for the business to require them to be on call. They're getting remunerated effectively for it, whether it be overtime rates or an allowance for making themselves available. And it's part of usual business practice. Is that kind of how we can take away from this?
Yeah, definitely. So it really depends if an employee is on call, what does that arrangement actually look like? Are they being paid for that period? Are they if they're on call, are they able to refuse contact and disconnect at some point during that on-call arrangement? If the on-call arrangement has set time periods of when they can and can't disconnect, then it can be really unclear. So I think they need to be looked at an individual basis. Every case can be so different. There's so many different factors to consider. But essentially, if there's a standby allowance, if they're being paid for that on-call arrangement and are being contacted outside of work hours, they probably can't refuse that contact.
Yeah. So thank you.
No worries.
All right. Well, we might start to wrap up unless anyone else has got any other last-minute questions. If you do have any other, I suppose, questions following this, obviously we've got the MPAQ advisory team that can answer a lot of questions as well, and we will have this recording sent out afterwards. There's the number there for the advisory line. Yeah, so we'll send out the recording following this, as well as that information in case you don't already have that. But yeah, thank you, Amy, for being here today. Thank you, Emma, for helping to organize everything. We do have a few other online events this year if it's of interest. We've got a webinar covering tax essentials for plumbing business owners next week. You can check out the MPAQ events page to find all the upcoming event details. But if there is anything else that you'd like to see covered in a webinar or in a workshop in the future, please feel free to reach out. But otherwise, if there's anything else that the MPAQ can help with, please let us know, and I hope everyone has a good week.